Okay, good morning.
Morning.
Okay, welcome to a session of oral arguments of the Fifth District Court of Appeal. We're here on the case of Lopez versus Avatar, case 20-64. I'm Judge Evander. The other members of the panel are Judge Edwards and Judge Harris. I do want to remind you that these oral arguments are being live streamed so that members of the public have an opportunity to watch them. As far as appellant's counsel, I'll assume you want 5 minutes. We reserve for rebuttal unless you tell me otherwise, and I'll try to help you in that regard, but there should be a clock on the screen that you can see so you can keep track of your own time as well. Okay, with that, if appellant wants to proceed.
Sure. Good morning, Your Honors. May it please the court, William Mueller of the law firm Kula & Associates on behalf of the appellant, Alexandra Lopez. The 5 minutes for rebuttal will be perfect. Thank you.
Okay.
On appeal before the court this morning is a summary judgment order that was entered in 2 identical first-party property cases that caused the forfeiture of my client's insurance coverage based on the sufficiency of a sworn proof of loss statement that she submitted to Avatar pre-suit. Now, I'm sure the panel is familiar with these sworn proof of loss statements. They are routinely considered to be conditions precedent to the filing of these first-party breach of contract claims. Now, this particular order that's before the court this morning not only weighed my client's compliance with that condition precedent, but it was born from a misrepresentation by the appellee's trial counsel that my client did not attach an itemized estimate of the cost of repairs to her property to her statement.
Counsel, what was done prior to the hearing by your client and her attorney to dispute the affidavit that had been filed that had the 1-page claim of proof of loss, but did not include the estimates? Anything?
Well, Your Honor, we did not file, if this is what Your Honor is asking about, oppositional evidence to the movement's motion for summary judgment.
Did you point out prior to the hearing that the affidavit was incorrect, that it did not attach the entire proof of loss forms or proof of loss plus estimates?
In our response to the motion for summary judgment, we answered the arguments that were made in the motion for summary judgment, which was that the 1-page form that the affidavit referred to was, as Avatar put it, a legal nullity because it was facially insufficient. I will refer the court to that motion for summary judgment. In fact, I believe that's on record page 538. And in that motion for summary judgment, Avatar's basis for moving for summary judgment was that the sworn proof of loss form that we submitted was, and I will quote here, contained other information needed by some other company for some other claim made by some other insured under some other policy. Our response to that motion for summary judgment addressed that particular challenge to the sworn proof of loss statement. That argument did not reference a insufficiency based upon a lack of attaching the itemized estimate of repairs. It frankly challenged the fact that we essentially filed an erroneous document in response to Avatar's request for production. Taking what that argument is literally, they're contending that we filed simply the wrong document in the wrong case.
That's not accurate, is it?
That is not accurate, not at all. I'll refer the court to both of the sworn proof of loss statements that we filed, even the single page document. They are clearly pertinent to these insurance claims. They have the right policy numbers, they have the right insured's name, they have the right insurer's name. They clearly belong to these insurance claims. And so when we
have the right claim numbers and the right claim dates, don't they?
They do, Your Honor, yes.
Were you able to understand appellee's argument that those documents had nothing whatsoever to do with these 2 claims?
I personally did not understand those arguments. And I think that essentially gets to the root of what Your Honor was asking. Avatar, as the movement for summary judgment, had the initial burden of conclusively demonstrating the absence of genuine issues of material fact with its evidence and its argument. Rule 1.510 subsection C places the burden on the movement to demonstrate and argue with particularity the facts and the matters of law that they are going to argue on summary judgment. To the extent they did that here, we addressed those inquiries by pointing out to the sufficiency of our sworn proof of law statements. And more,
Counsel, do you agree that the standard of review here is de novo?
I would agree, yes, Your Honor. It is a summary judgment order.
And by that, are we to review the same evidence that the trial judge was reviewing for summary judgment?
Yes, Your Honor.
The only evidence submitted for summary judgment was, I think his name is Barcina, his two affidavits, which attached the letters from Avatar and the one-page sworn proof of loss forms. Is that right?
That is correct, Your Honor.
Okay. Go ahead, sorry.
Is the denial of the motion for rehearing, is that reviewed under de novo? Is that reviewed under abuse of discretion?
Your Honor, I think I'm sure most of the orders denying rehearing that the court sees are typically reviewed for an abuse of discretion. In this particular case, however, the trial court made a legal determination that it could not consider factual matters unless they were couched or contained within an affidavit. That is a legal ruling that a movement for rehearing is limited to presenting an affidavit as opposed to discovery in this case. That's a threshold legal determination that I would submit to the court. You would be reviewing de novo in this case.
Okay.
And so I want to get back to what exactly Avatar had to prove through its motion for summary judgment. This court in its Allstate versus Farmer 2012 opinion allowed issues of compliance with a condition precedent in the first party property context and issues of prejudice to go to the jury. We submit that's how the process should have played out in this case. Farmer also cited with approval a 4th District Court of Appeal case, the Heyman versus Federal Insurance Company case. That's a 2001 case from the 4th District Court of Appeal, in which I think the 4th District was the first court to say, unless there's a total lack of compliance with a condition precedent, if there is, and they use the phrase, some degree of compliance with a condition precedent, then that should not be resolved as a matter of law. It should be sent to the jury as it was done in the Farmer opinion. Now, 2 weeks ago, we provided the court with a notice of supplemental authority that applied the Heyman principle to a sworn proof of law statement. Now, the 4th District Court reversed Avatar's summary judgment in that case, principally based on deficiencies with the affidavit they filed there, but it went on to instruct the trial court on remand, and I'll read the holding here. When an insured does submit a sworn proof of loss, the issue of whether the submitted document substantially complies with policy obligations is a question of fact, which precludes the entry of summary judgment.
Let me ask you this. On that second DCA case, is there any material difference in the affidavit submitted by Avatar in that case versus the one submitted in this case?
Upon review of both of the affidavits, Your Honor, there really is no material difference.
All right. One of the things the second said in their opinion was the affidavit did not reflect that the sworn statements were made by someone with personal knowledge. And I think, again, in this case, there's no reference to personal knowledge. Is that something that you would have to bring up in the summary judgment hearing below, or is that something that we can consider even though it was not brought up below?
I think it's a close call, Your Honor, to be honest. I think if we were to challenge the admissibility of an affidavit on appeal, that objection should be lodged in the trial court. However, if this court reviews de novo the sufficiency of evidence, then I do think it could properly consider the argument or the holding in Everett. And Your Honor was right. In Everett, the 2nd District Court of Appeals said just because you're a corporate representative does not give you a free pass to establish, without establishing the foundation, any documents attached to that affidavit. The same deficiencies are present in the 2 affidavits that were filed in this case. And so, make no mistake, I think even the trial court operating under the assumption that there was no itemized estimate of the repairs to the property should have not weighed the sufficiency of even that one-page statement, sworn proof of loss, on summary judgment. It is not, as the Hayman Court and as the Everett Court said, a total failure to comply. Perhaps Avatar deems that form to be insufficient, and it is free to argue that to the jury, as Hayman, Farmer, and Everett says it should. But on summary judgment, what occurred below should not have happened. And that is that the trial court was going sort of line item by line item through our form, weighing the sufficiency of each item. And so if there are no questions with respect to compliance, I'd like to move on to the issue of prejudice, which both parties have briefed rather extensively thus far. And so I'm going to keep it fairly short in the interest of time. The only thing I really want to add on the issue is that the most recent decision on the element of prejudice is the Third District Court's Shiv Dasani versus Universal Property and Casualty Insurance Company opinion that was issued late last year by the Third District Court of Appeal. And it stands for the proposition that regardless of whose burden it is to plead and to prove prejudice, the trial court should have at least considered the element before entering summary judgment and divesting uninsured from their insurance privileges. That was not.
Does the insurance company have to allege prejudice before we even get to the issue of who has the burden of proving prejudice or lack of prejudice?
I would think, I think so, Your Honor. Under Rule 1.120, the pleading rule, it is the defendant's burden to plead with specificity the affirmative defenses that they are alleging. Now, in this case, there was no answer filed. They moved for summary judgment directly after the filing of our amended complaint. And so if the requirement to plead with specificity exists in the answer, it so too should exist in the motion for summary judgment that's based on essentially an affirmative defense. And as we already reviewed, they did not do that. They did not allege prejudice. In fact, they told the trial court not to consider prejudice. Ironically, Exhibit A to their reply to our response to the motion for summary judgment contained the Shiv Dasani final judgment. Trial counsel for Avatar told the trial court, don't consider prejudice because of this final judgment. Now, of course, the opinion reflects that final judgment no longer stands, based precisely on the issue of prejudice. And so ultimately, I want to circle back to your question, Judge Evander, with respect to the order denying rehearing. We moved to clarify the misconception that the trial court had with respect to our estimate of repairs through that motion for rehearing. We really sought to plead and prove two facts. One, we were not put on adequate notice that they were going to argue that was the whole legal insufficiency of our sworn proof of loss statement. And two, simply that we had provided that estimate of repairs. The trial court denied rehearing, but it wasn't on the merits of either of those two claims. Instead, the trial court said that a party moving for rehearing is limited to the filing of affidavits to support the claims made therein. Now, there is, from my research, no legal authority that supports that legal determination. Rule 1.510 subsection C, again, actually lists discovery materials that can be considered on summary judgment. It lists out answers to interrogatories, admissions, depositions, and other materials as would be admissible as evidence. We provided discovery. We provided Avatar's own response to our request for production. That response indicated that they had received our estimate pre-suit and that they had it in their litigation file. So whether it was intentional or not, the representation that they did not have and that we did not attach it, I don't think it necessarily matters, but the facts were proven based on the evidence that we submitted to the trial court. And so based on that, I will reserve the rest of my time for rebuttal unless the court has any further questions.
All right, thank you. All right, Ms. Rooney.
Good morning. May it please the court. Carol Rooney for the appellee Avatar. Your Honors, I'd like to start out just with the maxiom that final judgments are presumed correct in Florida. And here, this final judgment can be affirmed on the basis of the appellant's failure to submit or rebut summary judgment evidence. Avatar moved for summary judgment really on three grounds. Number one, that the proof of loss was untimely submitted. Number two, that the proof of loss was deficient. It was not submitted on the proper forms that have been supplied by Avatar, and that Mrs. Lopez's spouse failed to sign the proof of loss as required by the contract. Now,
Counsel, let me ask you about the first issue. The trial court ruled against you on the timeliness, correct?
That is correct, Your Honor.
Cross appeal?
A cross appeal is not required, Your Honor.
Excuse me. Did you cross appeal?
No, Your Honor. Your Honor, our position is that this court could affirm on that issue based on the tipsy coachman rule.
Well, let me ask you about that, Ms. Rooney. Are you aware there's case law that says the tipsy coachman rule is inapplicable on summary judgment motions?
Your Honor, I'm aware of the Florida Supreme Court cases specifically, and I haven't cited to this, but I'm aware of Florida Supreme Court holding that an appellate court, in considering whether to uphold or overturn a lower court's judgment, is not limited to considering the reasons given by the trial court, but rather must affirm the judgment if it is legally correct regardless of those reasons. And that the appellee in arguing for affirmance of a judgment is not limited to the legal arguments expressly asserted as grounds for the judgment. So, Your Honor, our position is that the tipsy coachman rule applies to the three grounds that were raised by Avatar in support of final judgment, regardless of the trial court's reasoning in rejecting or accepting either of them.
But do you have any case law that deals specifically with summary judgments and the application of the tipsy coachman rule?
Your Honor, I believe I would rest on the cases cited in our brief, and I would also request that the court allow us to submit supplemental authority on that. That tipsy coachman does apply in the summary judgment context.
Let me ask you this. As far as the counter affidavit, would you agree that a counter affidavit is not required if the record otherwise indicates the existence of a disputed factual issue?
I would agree with that, Your Honor, but that's not what happened in this case, because in this case, we had an affidavit that established the exact date that the proof of loss was requested from Ms. Lopez and the exact date that the proof of loss was received by Avatar. So we have record evidence.
That's on the timeliness, but let's talk about the grounds that the trial judge ruled on. Wasn't that counter affidavit required?
A counter affidavit would have been required because we had record summary judgment evidence that the proof of loss was not substantially compliant. So that was never rebutted.
Okay, but the trial judge did not consider the attachment to the sworn proof of loss. Would you agree with that, at least at the initial hearing?
Yes, I would agree with that, Your Honor.
On the motion for rehearing, he denied it, saying there wasn't a counter affidavit. But that goes to my prior question. If it's otherwise in the record, does it need to be in a counter affidavit?
Your Honor, discovery responses are not in the record. When you respond to a request to produce, you don't file that with the trial court. You just send it to the other side. So it wasn't, number one, it wasn't record evidence. And number two, you still have to authenticate it to have it to be officially summary judgment evidence, meaning you have to attest.
You need to authenticate it if you produce, if you're, is your client that produced it as something it had received, that it had in its records.
But again, Your Honor, that wasn't record evidence. It wasn't filed with the trial court. It has to, according to the summary judgment rule, it has to be in the record. Just submitting.
Counsel, do you agree that it was a material misrepresentation for Avatar's counsel at the summary judgment hearing to say that no estimates had been submitted?
Your Honor, that was a mistake, an unfortunate mistake that counsel made, and he did admit to that in his response to the motion for rehearing.
Right,
that
on page 22 of his response to the motion, he finally admitted his mistake. But my question is, don't you agree that that was a material misrepresentation of fact to say that there was no estimate attached to either sworn proof of loss?
It was unintentional, Your Honor.
I'm not trying to say that it was intentional or merely negligent, but it was a material misrepresentation of a material fact, wasn't it?
It was significant, and it was unfortunate that trial counsel didn't realize what he was doing. But I would also point out to the court that apparently the other opposing side didn't misrepresent it as well. They didn't understand that they had done it. So there was mistakes on both sides.
They didn't make a misrepresentation. They sat silent, which I agree with you was not the best thing to do. The other question I have for you, Avatar, both in Brasina's 2 affidavits and in the motions for summary judgment and in the response to rehearing, continuously says that the sworn proof of loss that was filed was for some other company.
Correct.
Do you agree with that? I mean, the sworn statement of loss, both of them say it's to Avatar Property and Casualty Company. They both contain the correct policy numbers. Each one contains the proper claim number. Each one contains the insured's name and property address. Both of them claim water damage. How is it that they are to another company? Let's start with that. How are these claims to another company?
I think what was meant by that, Your Honor, is that they used a form that Avatar does not use that requires.
Where in the policy does it require the insured to use your form?
The policy doesn't require a specific form, but it does require specific information that's included in Avatar's form.
Okay, well, your side has represented in affidavits, motions, and its response to reconsideration that this sworn statement was for a claim to another company. Where do you get that from?
I believe, Your Honor, that has to be because it's not Avatar's form, so it has to be copied from another company.
In terms of who the claim is to, it's to Avatar Property and Casualty Insurance Company, correct, on both of them?
Yes, it does say that, Your Honor.
And each one lists the proper policy number, correct?
Yes, Your Honor. I believe they are correct.
And yet in the motions for summary judgment and affidavit, it says under some other policy. That's a misstatement, isn't it?
Your Honor, I don't know where they got that information from, but I think when they're referring to another policy, it's because of the material differences between the form requirements for Avatar and the form requirements for wherever they got this other form from.
What do you say? Well, what I'm saying is this. Your side has said throughout that these 2 sworn statements of proof of loss were for a different policy, which is not correct. You can't tell what claim they are when they have your company's claim number on each one of them that matches up with the letter from Avatar. It says who the named insured is, and they both say they're water losses. So my question to you, these representations were made by your side to the trial court that it's a legal nullity because it's for some other company, which there's no proof of that, for some other claim, when they're both the dates of claim and claim numbers that your insurance company provided, made by some other insured. Where is there any indication that this is made by any other insured other than Ms. Lopez?
Your Honor, I don't have an answer for that. I'm just going, that's not clear from the record.
I'm not surprised that you don't, but these were material representations made under oath by Avatar, its claim representative, Brasina, and made in the motions, stated during the hearing, and even made in the response to the motion for rehearing, that these claim forms basically were for another company, another insured, another claim. I mean, it's just, there is no support for that at all on the record, is there?
Your Honor, if I may cite directly from the affidavit, and I'm looking at record number 3394, it says specifically the document contained other information needed by some other company. And then it goes on to say what the problems were under some other policy. So you have to start with the statement, the document contained other information needed by some other company. And that's because the form that was used for the proof of loss is not Avatar's form.
But it provided every piece of information other than as to personal property loss and as to additional living expense requested and required under the policy, correct?
No, Your Honor, because Avatar's
What did it omit?
Avatar's form, and I'm looking at record 985, actually says, makes the affiant swear, I am or am not attaching estimates. I am or am not making a claim for the damaged building. I am or am not attaching an inventory which details the quantity, description, actual cash value, and amount of loss. I am or am not attaching receipts for additional living expenses. I am or am not attaching an affidavit or other evidence which supports any claim. This is what's required by affidavit or by Avatar. The proof of loss form that was submitted,
By your policy?
Your Honor, the policy requires that you submit a sworn proof of loss, and it does list the various categories of information you have to provide.
All right, it does. And the information to request is the address of the loss, the date of the loss. Those were provided, correct?
The date of the loss and the description, one word water, was provided.
Okay, that's not what you relied on in terms of motion for summary judgment, that you couldn't tell what the loss was, could you?
Well, Your Honor, again, the affidavit says it refers to this is what's required by some other company, information needed by some other company. And again, it's because the form that's provided by Avatar to its insureds that has all of this information that it requires was not provided. So that's
the estimate. Y'all have the estimate. That's one thing that was required by your form, correct?
Well, the form requires you to say whether you have an estimate or don't have an estimate, and that actually helps you to know whether or not, when you're going back 2 years later, to whether or not, because you have a form that actually verifies I am attaching an estimate or not, and this other form that was used by the policyholders, there's no indication of that, so that can unfortunately lead to some confusion, which is what happened here.
But y'all even produced the estimate in response to request for production. You gave it back to the insured's counsel with a cover letter saying it was there. So
that is correct, Your Honor. And Your Honor,
let me do a subject change here, Ms. Rooney. Would you agree that under current law, if as far as the sworn proof of loss being a condition proceeding to filing suit, that there must be a showing of prejudice? Now, let's leave out the discussion of who has the burden of proof, but you're not entitled to summary judgment for failure to file sworn proof of loss unless there's prejudice. Would you agree with that?
Your Honor, I wouldn't agree with how you phrase that, because once the movement, the insurance company shows that there's been a breach of post-loss compliance, then prejudice is presumed. And then the non-movement, the insured, has the burden to come forward to present summary judgment evidence that presents a disputed issue of fact.
Well, do we even get to the presumption of prejudice unless there's an allegation which put at issue?
I don't think.
If you came in, for instance, and said, Judge, we're not alleging prejudice, would that end your argument?
No, Your Honor, because prejudice is presumed. If it's presumed, I don't think.
No, but if you came in and said, Judge, we were not prejudiced. We're not alleging prejudice. We're not alleging prejudice. Would you lose?
If you're not alleging prejudice, that could be problematic.
Okay. But where did you allege prejudice here? I don't see it in the motion for summary judgment. There was no answer filed. So when did prejudice ever get put at issue?
It's legally put at issue because it's presumed once you have summary judgment evidence establishing a breach of post-loss compliance.
But if you do, but what's the difference between not alleging it and saying, Judge, we don't allege it?
I don't think there's a legal requirement to specifically allege it in a pleading or a motion once you've moved to establish breach of post-loss compliance and you have summry judgment evidence established.
Why is the burden on the other side to prove something that you're not alleging? As an affirmative defense. Would you agree it's an affirmative defense?
It's an affirmative defense.
Who has the burden of at least alleging an affirmative defense?
But a motion for summary judgment can be filed before an answer in affirmative defenses.
Where in the motion for summary judgment was prejudice alleged?
It was not alleged, but I don't think that had to be alleged. Our position is it's presumed once you establish a breach of post-loss compliance. And then the burden shifted to the policyholders to come forward with some summary judgment evidence to perhaps have a disputed issue of fact. And they never did that. And Your Honor,
I'm having trouble understanding why the opposing party has a burden of proving something that you're not even raising as an issue.
It's presumed. I don't think if it's presumed.
Presumed if it's alleged.
Okay, well, I guess, Your Honor, I respectfully disagree with the court that we didn't have to specifically allege in our motion that we were prejudiced as long as we alleged there was a breach of post-loss compliance. So that's our position on the issue of prejudice. And as far as the argument.
Mr. Rooney, I want to go back to something before we run out of time and talk about that second issue that was raised in the summary judgment, the one that the court did grant the judgment on, that did involve a misrepresentation. I mean, he found that there was basically no way from what he was given to show where the plaintiff came up with this $28,000 figure or whatever, right?
Correct.
Part of his ruling is there's no attachment or anything. At that point, trial counsel, was it Mr. Allen, was aware that no, there was an attachment. I mean, he had seen it at some point. I would think he would have had a duty at that point to speak up and say something. But, this whole thing seems like it could have been corrected at that point. And that's what's troubling here. It seems to be as I think Judge Edwards pointed out earlier, a material misrepresentation that there was no attachment to the form. And you, in your brief, and again today, try to minimize that material misrepresentation by saying it was unintentional or that he misspoke or that it was a misunderstanding and that he apologized for it. Well, so what? I mean, this was after the summary judgment was entered. Don't you think if the trial judge would have known that this attachment was in fact attached to the proof of loss, he would have said, well, that's a fact issue as to whether it's substantial, no summary judgment. Don't you think that was kind of a big deal?
That is, yes, Your Honor, that is very possible. And I don't intend to minimize, that's not my intention to minimize what happened.
But you've been doing that. You did it in your brief, you did it again today. I don't know what's more troubling to me, the fact that trial counsel did not at rehearing concede that summary judgment should not have been entered, or that you've refused to do it in this appeal. I'm troubled by both of those.
Your Honor, I think in our brief, we did focus on that there was other grounds though. If there was no other grounds other than the missing estimates, then I would agree with Your Honor, but there was other grounds that supported summary judgment, and that was the untimely proof of loss and the spouse failing to sign the proof of loss. And counsel did admit in his response to the motion for rehearing that he did make a mistake about the estimates not being attached, and he apologized for that. And it certainly
told the court, but then he told the court not to consider it since no affidavit had been presented.
Well, Your Honor, that they should have actually submitted that to the court in the form of an affidavit to authenticate it and to make it summary judgment evidence. So I think
there was no dispute by the time of rehearing and the response to rehearing that the estimates had been attached, and the ones that were attached to the motion for rehearing were accurate. I mean, it showed it coming from your firm in terms of responding to the request for production. I mean, you're basically saying that the appellant didn't properly prove with an affidavit that your partner misled the court about the lack of estimates being filed. That I agree. That's very troubling to me that, in the Farmer case, I talk about winning on technicalities is frowned upon. This is beyond that.
Your Honor, and I agree, it might have appeared to be a hyper-technical argument, but it was a legally correct argument in terms of they should have used an affidavit, submitted that to the court with the affidavit, and they didn't do that. And I don't know.
Wouldn't a correction of a misrepresentation include saying you should consider this? You know, the motion for a hearing, Judge, I did misrepresent. You should consider the estimate and make your decision based on the awareness of the estimate being or the estimate having been attached to the sworn proof of loss. Wouldn't that be the way of correcting a misrepresentation as opposed to making a misrepresentation saying, yeah, Judge, I made a material misrepresentation, but don't consider that fact. Just consider the case as if the material misrepresentation had not been made.
Your Honor, I think that what happened at that point is trial counsel went through in their response to motion for rehearing and detailed all these other issues and problems with the actual estimates.
The bottom line,
yeah.
allows the court not to consider the estimate being attached to the sworn proof of loss. In the response to the motion for rehearing, that was the bottom line on that issue.
For other reasons, as well as it not being attached to an affidavit, he went through and detailed all the different problems with the estimates, Your Honor. So, our position is that this, although it might seem hyper-technical, that this final judgment can be affirmed purely on just technical grounds of not complying with the rules of summary judgment and presenting summary judgment evidence. And there were other grounds besides the estimates, the timeliness and the spouse not signing the proof of loss. So
if we wrote a detailed opinion agreeing with your position, would that send a signal to the bar that it's okay to make material misrepresentations and win as long as the other side is not, conscientious enough to catch it?
no, I don't think so, Your Honor, because you would still be applying Florida law and waiver and preservation and complying with the summary judgment rules still applies. You could certainly, trial counsel apologized. He made a mistake. He shouldn't have done what he did. And I think he tried to fix it. Maybe he could have done more to make it better, but he acknowledged that he did make a mistake. The other side made a mistake and forgot about the estimates as well at the summary judgment hearing. It was an unfortunate situation all the way around. I don't want to minimize that at all. It was a mistake. It wasn't intentional, but there are other grounds to support summary judgment, and we are entitled to request that this court affirm the summary judgment on those other grounds. And really, that's all we're intending to do here today is to, yes, thank you, Your Honor.
Any rebuttal?
I will keep it very brief, Your Honor. May it please the court. I have two record cites and just 2 points to make. The first record cite, we were told by counsel this morning that their response to our request for production was not record evidence. That's not true. I'll refer the court to page 1653 through 1884 of the record. Their response to our request for production was filed before the summary judgment proceedings. Record cite 2, 2284, that is Avatar describing the form that they enclosed with their request to submit a sworn proof of loss as one merely for convenience purposes, not required by the policy. They didn't ask for it in their request to submit a sworn proof of loss as mandatory. It's merely for convenience. 2 points I want to make. Tipsy Coachman does not serve to reverse a trial court ruling unless you cross appeal, which is effectively what this court would have to do in order to reverse on the timeliness issue. There's an adverse ruling on the books against Avatar. Tipsy Coachman cannot work to reverse that judgment or that ruling in Avatar's favor. It would work perhaps if they had claimed it with respect to the signature issue, because that was not ruled upon by the trial court. That's a more appropriate Tipsy Coachman argument. This is an adverse ruling. You cannot Tipsy Coachman an adverse ruling. You have to cross appeal that. And finally, I want to conclude on just a sort of practical boots on the ground sort of approach. What's the purpose of the sworn proof of loss? This court described it in Farmer as simply an aid to the insurance company's investigation of the claim. Not only have we not heard how Avatar was prejudiced by our sworn proof of loss, but they never even said how they were impeded in their investigation of the claim by the forms we submitted. They simply moved for summary judgment on very technical grounds without ever describing how this had any practical impact on the insurance claim. And so, unless there are any questions, I will wrap up here and respectfully ask the court to reverse the trial court summary judgment. It's denial of a rehearing as the court wishes.
All right, thank you.